Hi, Stefano Molea, San Diego criminal defense lawyer and partner at the law office of David P. Shapiro, where we help good people regain control of their future when charged with a crime. In this video, I'll provide a breakdown of voluntary manslaughter in the context of being charged with murder. If someone is charged with murder under Penal Code Section 187, it might be appropriate, depending on the factual scenario of the case, for the court to provide a jury with a voluntary manslaughter instruction based on Penal Code Section 192, subsection A. In essence, murder could be reduced to voluntary manslaughter if the killing happened due to a sudden quarrel or in the heat of passion. A case can go from a murder to voluntary manslaughter if the defendant was 1. Provoked, 2. The provocation caused the defendant to act rashly and under the influence of intense emotion that obscured reasoning or judgment. And 3, a reasonable person would find the provocation enough to act rashly without what they call due deliberation. Now look, a defendant can't just set up the provocation and set up his or her own standard of conduct, is what the jury instructions say. The jury would have to decide whether the provocation was reasonable to create the sudden quarrel or heat of passion. And one of the factors that the jury considers is whether enough time has gone by between the provocation and the act. If the defendant cools off, right, has enough time to relax, he or she can't rely on the provocation to reduce the killing from murder to voluntary manslaughter. Now in the movies, the classic heat of passion scenario is finding a significant other in bed with someone else. But that doesn't automatically give someone a license to kill and have a murder charge reduced. These cases are all about the detail, and ultimately it's a jury that decides whether something is reasonable. Hope this explanation was helpful. If you have any questions, give me a call. Stefano Molea, San Diego criminal lawyer, 619-295-3555.